I think more and more law firms will be using AI, and you can kind of tell that would solve and how fast they're growing. I think the value actually will be the AI would help rid attorneys of the busy work and help them actually focus on the legal.
It's almost as if everybody now with AI has a team of people working under them, whether you're, a paralegal or associate level person all the way up to a senior partner. Now everybody kind of has with AI kind of these agentic systems that help them get their work done.
When you start looking at a number of these systems, they are fantastic. But at the same time, and I think all attorneys need to know how AI works and also reviewing the results, because there's tons of cases all over the country with AI creating fake case law and then citing those in motions, and then those being caught by judges and the other parties.
Hey everyone, welcome back to the Ignite podcast. Today we're thrilled to have Dina Blikshteyn on the mic. She is a partner in the intellectual property practice group at Haynes Boone in New York, co-chair of the firm's artificial intelligence practice, an expert at the intersection of patent law and emerging tech, and a frequent speaker and writer on AI, patent eligibility, and tech regulation. Dina brings both technical expertise from her early career developing high-frequency trading systems and seasoned legal perspectives shaping how innovators protect and deploy their technologies. Thanks for coming on, Dina.
Thanks, Brian. It's always great to be here and do a podcast.
Yeah, so I'd love to get your origin story. What's your background?
So my background is in computer and electrical engineering. So I was a computer geek. I did a lot of computer engineering, computer science work, ended up on Wall Street, and then decided after spending about 5 years there that I needed more human interaction and went to law school at night. So then lo and behold, we fast forward 15 years later, and I am still doing technology, but on the legal angle. And now I'm also, throw AI into the mix, so extremely math heavy. So now it's computer engineering, computer science, AI, and
yeah, so you very much live at the intersection of law and IP, but also like AI and technology. Yeah, very interesting. I had the same realization 20 years ago when I worked on Wall Street. Staring at a spreadsheet and analysis all day, every day was not for me. I enjoyed the work, but not 80 hours a week or whatever. How do you think your technical background shapes your approach to IP and later AI?
Quite a bit, actually, because with a technical background and then also working in the industry, I know how technical systems work on a perspective of a developer. So when I talk with inventors about either helping them obtain patents or invalidating patents, all that background comes into play. So it's a lot less theoretical and more hands-on. And then I'm applying that to the legal concepts.
What are some challenges you faced when working on patents in cutting edge tech fields?
Challenges when I help inventors get patents.
Yeah. What are some of these challenges around, let's just take AI. We're an early stage venture capital firm. We're backing, around 100 early stage firms a year. As founders approach us, how should we counsel them? Obviously get them in touch with you, but what are some of the challenges that they face, when they're trying to protect their IP?
So, the biggest challenge that I'm seeing is IP is not a priority, right? And neither it should be when you're just a startup, but that comes with consequences, right? So in US, you have a 1-year grace period to file a patent application from an earliest disclosure. And other countries, it is an absolute bar. Essentially, you have to file for a patent application before any disclosure. So at the time the startups actually figure out they need a patent and want to file up for a patent, it's just too late, and the patent protection is not available to protect their crown jewels. Now, they can file on improvements, but more often than not, you want to protect the core technology, and sometimes it's just, from a legal perspective, it's too late.
Maybe you could define for the audience what the notice is versus the actual patent. There's a lot of entrepreneurs that listen and probably don't know the difference.
All right. So when you file a patent application, right, you essentially get a date from the patent office of when the patent application is filed, right? It takes about 3 years to have the patent issued, sometimes a bit more, sometimes a bit less, right? But your protection starts from the filing date, right? Now, if you're a startup going 100 miles an hour and trying to develop technology, you will be talking to different VCs, or you will be talking about it publicly or submitting submissions to different conferences that outline your technology. All of that is public disclosure. And that starts the clock for filing the patent application. So in US, you have 1 year to file from the earliest disclosure that you make, and that's without the NDA. And in the rest of the world, you can't do any disclosure.
Yeah, maybe tease that out a little bit, because a lot of the startups we back obviously are US based. How should they be thinking about the international filings, if at all?
So you want to file where A, you can protect the technology, and B, where you're doing business, right? You don't need to file in every single country in the world, and we recommend against those types of filings, right? So if you're in the tech space, typically it's US, Europe, and then you pick several countries in Asia. It can be China, India, South Korea, for example, sometimes Japan. But it always goes back to the business case, right? Where will people use your technology and where it will be sold? And also how much of an appetite you think you'll be protecting it worldwide. Now, I know if you're a VC, you're looking at it the opposite way, right? Where is the technology being protected when you're looking at different companies? So it's always a calculus, but it's a business calculus more than a legal calculus of where a company should be filing versus what would be the long-term benefit from those, right? And you don't need to file on everything, right? You don't need to file on every single technological improvement, especially for startups. Like our recommendation, 1 to 2 patents. You can start in US and then you can decide whether you want to file globally down the road, and make sure that's directed at the crown jewels of the technology.
So you probably talk to lots of founders who think they have really unique IP, but upon review, they don't. Tell us some of the common traps or pitfalls or ways that founders actually don't have patentable IP that they think they do.
Right. Okay. So there's usually 2 groups of people. That one group thinks that everything's novel, and the other group that thinks that nothing is novel and we don't need to file patents. If you're money conscious, especially in the beginning, you can always do your own search to see what's out there. And the easiest and free way to do it is to do Google Patents, and then you can kind of see what's already out there. Something to remember is that most patent applications don't get published right away. There's about an 18-month lag, unless a patent issues before that. So you're a bit behind the technology when you do those searches. But at the same time, doing a search can give you a fairly quick sense of what is out there technology-wise.
So how should a startup think about patent strategy versus other forms of protection like trade secrets or trademarks?
Okay, so there are 4 types of protections, right? And you mentioned 3 of them, and the last one is copyright. And they all work together, right? So a lot of startups think, well, we'll just do everything a trade secret. Well, it doesn't work for a number of reasons. On when you shop around, you are doing the disclosure under the NDA. And then you run a risk of someone saying, well, I'm going to file a patent application on your technology.
So tell us more about that. There's a disclosure under NDA. What does that mean?
Disclosure under an NDA is when you sign a document. It's essentially a non-disclosure agreement where if I'm a startup, I'll say, I will tell you about my invention and you agree not to disclose it outside of our conversation. Right? Does it always work practically? Maybe yes, maybe no, right? You can also have instances where you have developers leave, right? And while they can't take the source code, because that would be covered under an NDA as well, or non-compete agreement, they can still take the know-how and try to build their own product.
Right.
Right. And then the other one, and this is always true in the AI space, since it's such a hot and emerging field, a lot of talent likes to publish at conferences. And
right.
What do they publish on, right? Whatever they are inventing, whatever they're coding, whatever their research is in. So while you as a company or a startup think that something can be a trade secret, if you have a paper that published something the same or similar, that is the genie out of the bottle that you can.
Yeah. So like if I'm a AI researcher at Google, name your favorite company. And, I'm on the research team. I'm not in the applied engineering team, actually shipping products. I'm doing like primary research. There's this kind of push that if I'm a PhD, I want to publish. What are some considerations for organizations as they scale to kind of maybe say, hey, researcher, maybe don't publish that in archive or at the next, AI conference.
Okay.
We're gonna, how should organizations think about that?
It's always a balance between, small, medium, and large organizations. And if it's a large organization, there's typically a program in place where they say, yes, go ahead, publish, but we will file for a patent application the day before you do the submission. Right? That way, the technology is protected. And if you're a researcher wanting to publish, you can go ahead and submit your paper for the publication. If you're looking at the startups or you're looking at medium-sized companies, it becomes more problematic because at that point, they have to make a business decision. Like, do we submit or not submit, or do we file for the patent application or not?
Are there any, to the degree that you could speak about, any interesting stories? I mean, you could change the names to protect the innocent, but are there any interesting stories where you were surprised or where you're like, okay, this is like a shoe-in, this is definitely protectable IP and it wasn't, or vice versa? You didn't think it was protectable IP and it ended up being?
I've seen a lot of cases where I didn't think something would get patented, and lo and behold, it was. And not only was it patented, the protection was also extremely broad. So that's the surprises you have, especially in the tech space. Right now, in the healthcare and AI, I expect to see a lot of those types of claims there as well. Because you have to remember, right? Every time that there is a new technology, the patent office examiners have to come up to speed on the technology. And while they're coming up to speed, that's really your chance to file for patent applications and get broad claims, right? Because then once the field gets saturated, the claims will become lengthier and more narrow.
Yeah, I mean, the most famous example in the current platform shifts that we have is the transformer architecture out of Google, which was published in 2017, right? But since they published it, it's not protected. I bet Google. Do you think Google's like, oh man, maybe we should have, instead of publishing that research, we should have just, protected it with a patent?
I have a counter story to that. So this is one with it's publicly known with OpenAI. So when OpenAI became public and the ChatGPT came out, it was all about, well, we don't need patents because all this technology has existed long before. And then, lo and behold, after ChatGPT became popular, they started filing for patent applications on improvement. And they were getting patents. And they were also filing under Track 1, which essentially for Track 1, you pay an exorbitant fee in thousands of dollars, and you can jump to the front of the line at the patent office. So
interesting. So they have like the Disney Fast Pass for patents, where you pay some extra money,
exactly,
and the patent office will review you next.
Exactly.
So you can pay for,
within a year, you can get a number of patents if you pursue that route. So what I started seeing is all of a sudden you have OpenAI who went from the mantra, we don't need patents, to filing a lot of patent applications in the LLM space.
How has this platform shift? I mean, obviously you started 15 years ago in law, you said. So you kind of started during the kind of the mobile and cloud kind of boom. How is this AI platform shift the same or different from kind of the previous platform shifts that we've lived through?
It's I can't say it's different, but we are on this cusp. There's a lot of innovation going on. So a lot of companies are just filing for a lot of patents just to have their piece of the pie. And then, so I've seen that a lot in the beginning around 2018, peaking around 2022, where you can actually file for a patent application and get claims that were fairly broad from the patent office. Right now, you're sort of seeing the field being saturated a bit, but now you're seeing innovation based on technology types. So for example, AI in healthcare is becoming extremely popular, and I see a lot of filings in that space.
Makes sense. So, I get my patent, I'm scaling, revenues going up and to the right, everybody's happy. But then I notice, 3, 4, 5 competitors crop up. How do I inspect and prove that they've somehow stolen my IP? Like I'm looking at it and like, this feels the same as what I'm doing. Like it's same input, gets the same output. There must be something in that black box that I'm not seeing that I'm curious or suspicious of.
Right.
So how do you prove that? That's from the outside looking in. It's pretty hard, right?
It's not always easy, but you have to look at the claims of your patent. And again, the claims, not the entire specification, because claims is where the protection is. And you can Search online and you can see if the claims map to their technology. Now, if you're sure, you can always file a complaint with the courts, and that would open up discovery where you can actually go into their systems and see how they work.
So is it an impartial third party that does that investigation? It would have to be, right? Because if company A is accusing company B, it's not like companies A's engineers, the plaintiffs, are going to get access to the defendant's systems, right?
Right. So the plaintiffs may not get access, but their attorneys may get access, and they may not be able to disclose to their client what they've been looking at, or they hire an expert to do that. Right. And the expert can tell the attorneys, yes, there is infringement. No, there is no infringement. And then the attorney can take that to the client.
Really interesting. Yeah. So the attorneys get involved, but then you guys have to, have somebody like you on staff that understands code, understands the space, but also you can hire experts in discovery to sort of make that determination.
Exactly.
And
you don't always need to pursue the litigation route, right? Sometimes you can tell there is infringement. Sometimes it's your former employee who opens up their own company, right? So at that point, you can kind of see that they're all doing almost the same thing, and that may be covered by your patent, right? So sometimes it's just a communication saying, I believe you're infringing my patent, and you can send a cease and desist letter. Would that always work? Probably not, but you also have to do a calculus. How much money is at stake?
Yeah. So what percentage of patent cases end up in like a settlement? Like, what are some of the outcomes and rough statistics around this space? It's completely fascinating. I have no idea.
Right. So it's not an easy question to answer because there's a lot more complaints filed than trials. So someone gave a statistic that it's about 5% of cases actually make it to trial, and most of them settle before that. Right now, the question is, when will they settle? Will they settle in the beginning? Will they settle closer to the trial? That depends on the discovery that can take, whether there's actual infringement or what else is going on in the case. There's also parallel proceedings called post-grant proceedings in front of the patent office. Right. So say if I have a patent and I sue you for patent infringement, you can file a petition at the patent office saying that patent is invalid, right? And now, the proceedings from the patent office, they're very quick. They're about a year from institution to the final decision. So roughly 18 months from start to finish, if you take if you count in the preparation time, right? So now you can use the post-grant proceedings to force settlement and litigation. So there's a lot of different strategies that you can take.
That's fascinating. Are there any famous examples where it made a company successful or broke a company, where a company was like, wow, we got to shut down, or eventually just kind of petered out because there was a case decided against them that was existential?
I don't want to talk about them.
Publicly well-known ones, like the Amazon buy now button comes to mind, right? They had the buy now button. They put a patent on it. Other people tried to copy it. And I think Amazon sued them and won.
Right.
But I don't recall the
There's also an eye for eye case, which is actually that one I can probably talk about because it's more than a decade old, right, where it was also a post-grant proceeding that I think ended up in a $400 million verdict in district courts, right? So that is an example of a startup taking on Microsoft, right? And Microsoft did not want to settle.
Wow, they took it all the way to trial.
The way to trial, and that was a $400 million verdict in 2010, 2011 was a lot of money.
What was the technology that was in dispute?
It was the Word document technology, like XML type technology.
Right. And what was the startup in this case?
i4i.
i4i, I don't recall them. And maybe that's indicative of this $400 million ruling kind of put them out of business, basically.
Well, no, they won. They won against Microsoft. They won.
Wow. So what were the particulars of that case where they were able to argue and win a settlement or win a ruling? Yeah.
So, Microsoft alleged that the patent was invalid and not infringed. Right. And they did not want to settle. They took it all the way to trial. And I guess they were wrong.
That's crazy. So from that situation, how can, what are some of the lessons from that case that startups can take away and apply as they're developing new IP? So
you should really talk to an attorney or a patent attorney it doesn't have to be one, it can be several. Somebody who understands the technology, because a lot of what I'm seeing on my end, especially with startups, they can say, well, we can write our own patent application, but
I'll
they
just
don't
use
understand.
ChatGPT, right? I'll plug it in
Right,
and yeah.
exactly. Yeah, and ChatGPT will give you claims. Will it give you defensible claims? Probably not. Right. So that's when the skill comes in, right? To make sure you have quality claims that you can get through the patent office. Because there's a huge difference if you look at a claim that's 150 words or that's 500 words. It's a lot more narrow. Narrower claims are harder to infringe.
Yeah. And so AI is changing how this is done. You recently joined the advisory board for Solve Intelligence, which is a portfolio company. It's how we got in touch.
Mm-hmm.
What is it about their approach or about AI that's kind of changing how this work is done and maybe accelerating patents and IP?
So Solve is really at cutting edge of what they do. And the way Solve works, it minimizes the busy work that an attorney needs to do. And it actually lets us focus on the legal work, like how to draft the best possible claims. Do the claims have support in the specification? Like, what are different claim types that we can do and what can we direct it on? Because remember, say you have a system with a client and a server, right? You can write claims directed at the server, you can do it directed at the client, and you can do it directed at both, right? Now, keep in mind, there's probably two different entities who own the client and the server, right? So those claims may not necessarily be the best ones for infringement, especially if you're looking to enforce it against one party, right? So with Solve can help me draft spec while I'm focusing my legal expertise on the claims to make sure good quality claims are written and those get through the patent office.
Interesting. So it's accelerating the legal work that can actually get done, which is what any good technology does. It's a leverage.
It's a leverage to minimize the busy work and focus on the high value legal work. Because it's like the same thing as asking a question out of any chatbot. Depending on the type of the question and the type of the prompt, you may get a good output or bad output.
Right. So there's this meme or idea floating around in tech circles that there are no moats. Execution and speed is your only moat. Would you agree with that, or are there still moats given AI?
I think there's still moats. It's just you need to figure out what they are and where the boundary is.
Yeah. So there's lots of startups out there, at the application layer, with a platform shift like large language models have been. There's this disparagement where, oh, you're just a chat GPT wrapper, you're just sitting on top of their tech and you don't actually add any value. How do you respond to all the application startups out there that are kind of building on top of foundational models? Okay, so like, what should they look for? What are some areas that are commonly patentable?
Okay, so your question, if I convert it to patent terms, it's patenting the LLM model itself, or it's patenting the system as a whole?
Yeah, it's probably the system that sits on top of the LLM, right? Because the LLM is, you can swap it in and out like a database, right?
Right. I mean, unless you're the LLM provider and you're actually looking how to make the LLM faster. So if you're an LLM provider, that's where you'll be filing your patent applications. If you are looking at the entire system, what we would recommend filing at specific components, right? How do you have an application? How is it different from whatever has been filed? Are there any improvements that you're doing on the input or the output? Like, what is your final output product, right? Can I file a patent application on that, right? So you're looking at the entire system, you're figuring out where the value is, and you're trying to direct the patent applications on that value.
What are some famous, because patents, they last for a couple decades typically, right? About 20 years?
20 years from filing.
From filing, not from awarding, but from filing, from the initial
20 years from filing for utility patents.
Yeah.
Plus whatever extra time the patent office took to examine it. So it may vary a little bit, but generally 20 years.
Yeah. Which is interesting. I think in like pharmaceuticals, you develop a compound, some new drug. The 20 years is really lucrative. If you have the semaglutide GLP-1 patent, like that could be very lucrative. But with technology moves so fast, right? There's every year or two, there's some new model, some new platform. How do technology companies think about this?
I see where you're going with this, Brian. But I think if you look at what the age of the patents when they're being asserted, they're all over 10 years old. So even though the technology is changing, if the patents are drafted well, they would apply to that future technology. Right. That's why if you look at big companies, they also file multiple patent applications in different fields and on different technologies, because they won't assert all of them, but they'll assert maybe a handful.
I see a lot of startups wrestle with closed source versus open source. How do you advise clients, if you have advised clients in this area, to think through going open source versus closed source?
Yeah, and it's a catch-22 for startups, because they do like to go open source. You can still use open source where the end product is something that's inventive. You're not getting a patent on open source. You're getting a patent on your entire system or a portion of that system. So you can still use open source and have something be inventive and patent.
Right. It's tricky though. Like if somebody submits a pull request into a repo and the license says, now I own that, I'm the company and now I own that. It's tricky legal waters, right?
It is tricky, but you won't be getting a patent on that repo request. You're getting patent on something that's specific to you and to your technology and to your area, right? Because the way I look at it, open source, it's a tool of how to make your invention work, right? And you have to combine multiple functions of that open source to achieve a result. So that combination may be.
Yeah. How has, AI regulation and law in this area kind of evolved over the last 5 or 10 years?
It's evolving and it doesn't stop to evolve, right? So especially with this administration, they're very pro AI innovation. So what they're doing is minimizing legislation on the federal level with a Trump's executive order. And essentially they're saying develop AI as quickly as possible for national security reasons.
Right, because some of the states were trying to develop their own laws. Oh, you got to do this in Colorado, you got to do this in New York, you got to do this here and there.
You're correct. So the states are trying to step in. And if you look at the previous administration, there was a lot of proposed state legislation that has never been enacted because there was an administration change. Right. So if you're talking about the Colorado AI Act, so that was, I think it was like 2024, I think it was May 2024, it was enacted. It was supposed to go into effect of January 1st. Now it's delayed, right, until June, right? And this administration has been very forward in its thinking that states should not legislate AI on a state level. It should be done on a federal level. And at the same time, this administration wants AI to develop with as little oversight as possible. Right. Now compare that to Europe, right? You had an EU AI Act that they've enforced with different levels for different types of systems, with high risk, low risk, medium risk, right? And then all of a sudden you have startups who have trouble innovating in Europe because they don't know which of those risk categories apply or if they apply, right? So there's a school of thought that the EU AI Act actually is stifling innovation, especially for the smaller and medium companies.
Yeah, it's kind of interesting, right? Because some governments will try to, it's very unusual that a government kind of steps in and tries to regulate something before it's harmful. Usually regulations are more of a reaction to harm already inflicted. Like the smog in California, right? You had all the regulations around CARB and clean emissions and stuff like that, which was a reaction to all the smog sitting in LA and stuff and other places in California. It's really interesting that states would try to go, oh, AI could be really powerful and harmful, so we'll try to get ahead of it. It's kind of an unusual stance I don't usually see from governments.
I think it depends on the state, because we had the same issue with the privacy law, because the EU has a really firm, right, the legislation of privacy law.
The GDPR 10 years ago.
GDPR, right, and then in the United States, there's no federal privacy law. So you have states like California who are trying to regulate it on the state level, and some states do so more so than others. And it seems like AI was going in that direction until this administration has been actively trying to discourage that. Right. So you remember like my big, beautiful bill. So because who could forget that, right? As part of that bill, they wanted to impose a 10-year moratorium on the states for AI legislation. Now that failed. But what if you start reading Trump's executive orders and subsequent orders? What he's saying is if if the states would try to legislate AI in a way that we don't agree, that would impact the state funding.
Interesting. So the
So
executive
this
branch in
administration,
the state,
it's all for developing AI with I don't want to say as little oversight as possible, but it seems like they want to give companies a chance to develop AI and then try to legislate it. Right. But then again, if you are a startup, just keep in mind there are frameworks that are in place, right, such as NIST and ISO that have the risk analysis, the risk assessment frameworks for AI that companies still use. It's just at this point, instead of that maybe seem as more optional than mandatory.
Yeah. So you threw out a couple acronyms there that the audience may not be aware of. Maybe you could define NIST and ISO.
I always forget what NIST stands for.
What is the spirit of that? How does it matter to founders?
Okay, so NIST, it's a risk assessment framework for AI, right? And the other one is ISO 42001. And it's all about AI governance. What is a high risk system? What is a low risk system? How do you implement a risk framework so your AI is deemed safe and ethical? And how do you apply proper AI governance, depending on whether you develop your own AI tools or whether you use third parties' AI tools?
We talked about the last 5 or 10 years of changes. How do you see it kind of unfolding over the next, remainder of the decade, over the next 4 or 5 years?
In US, I think the next 2 years, there's going to be a lot of innovation. After that, it will depend on whether there is or isn't a change in administration. So we may get, if there is a change in administration, we may move towards pro AI governance, then go back to, I don't want to say EU AI Act, but something that's similar and moving more in that direction. If there isn't, there'll be continuing a lot of AI innovation with not as much federal oversight. I think what's going to happen is something that's happening with the copyright law, where it just have to go through courts. And at some point, when we get a Supreme Court case to see what can be done about AI and copyright, right? And if that is infringement or not. But at this point, there's just it's just weaving its way through courts.
Yeah, and the kind of the most famous right now with this current paradigm shift is probably OpenAI versus New York Times, or New York Times versus OpenAI, right?
I think there's about 39 different cases that are pending, mostly in California and New York. Some of them are consolidated. But there is a question of whether training AI model on copyrighted data or not copyrighted data is fair use or not. And different judges apply the 4 factors differently.
How do you think, if and when it makes it all the way to the Supreme Court, if you had a crystal ball, how do you think the fair use kind of comes down with AI models?
It will be fact specific. Because, the problem is not fair use or using your books on AI, right? It's the fact that all these LLM models, they can create something that's extremely similar to artists' work. And then the value of the entire work just crashes.
Tell us more.
Okay. So if I'm an author or if I write songs, as a company right now, you can buy my song or my book, and because that's valid, that's not infringement. And then you can use it to train AI model. All right. And now what a lot of AI providers are doing, they're putting, I don't want to say it's firewalls, but essentially they're putting, I say firewalls on the inputs and the outputs. So you can get content that's the same as my work. Right. So they'll change a word here and there. Right. So that's not infringement. But at the same time, once trained, that model can still produce work that's very similar to my own, that's in my style, but that uses different words, right? So there's
like a university would train a human being to read a bunch of books, and you could argue that a PhD is just regurgitating other people's ideas.
You're right, but you absolutely can. But now you look at the speed, right? How fast can a PhD replicate my work as opposed to how fast an LLM can do it? Right. And at which point a value of my work would just plummet exponentially.
Yeah, that's really fascinating.
So I think it's going to be the same thing as what happened with Napster. There's going to be a change in the industry, right, on how work are getting evaluated and where the value is. Because remember, we went from CDs with the music to now individual songs that can be downloaded to your playlist. I think at some point with AI and copyright, we'll see the same type of a change.
Right. Well, I think it's a little different because, I ingest a book and train on it. There are ideas in that book that I can then summarize, right? Or regurgitate. And so you think ultimately we're going to have to develop a system to compensate the authors of every book ever written that's still like under copyright?
Potentially, right? Assuming, but you have to remember for copyright infringement, at least straight non-derivative copyright infringement, it has to be the same thing, right? It's the
Okay,
same,
maybe you could
same output
tease
is the
that
input.
out.
So same
there's
output is
derivative
the input.
works and non-derivative works. Maybe you could like what's the difference?
So the derivative works are the works that can be different from the actual work, hence it's a derivative. So I'll give you an example with a Mickey Mouse, right? Recently, Disney changed how Mickey Mouse and Minnie Mouse, how they all look, because the copyright on the Mickey Mouse has about to expire if it hasn't already. So that second, slightly different Mickey Mouse, Minnie Mouse, that's the derivative. All right.
And that's
so now
copyrightable?
it's copyright. You can copyright derivative works for like another 70 plus years.
How do you think that applies to books and AI and articles in New York Times now?
Well, that's right. So that's sort of the issue, because if you have a book that's going through the AI model and you have the AI model provider that's modifying the content, right? It's not direct infringement anymore because the input is different from the output. Right, the question becomes, can it be a derivative?
And if the court rules that it is a derivative work, then the IP copyright flows back to the original?
Potentially, yes, but it will be fact specific. I think like if you start looking at it just in terms of policy, all right, it's not the fact that AI can infringe one work, is that the value of the author's work will become extremely low, just because AI can replicate the author's style, which may not fall under copyright infringement or under derivative infringement.
Yeah, that's like almost arguing that like a book review or a Wikipedia page is, infringing on my copyright of like me as an author.
Right.
But not really, right? Because it's just writing a summary of the book.
Exactly.
Your book report doesn't infringe on my copyright necessarily. But if you write a whole nother book that's effectively the same book, just rephrased.
Well, it can be a different book. It can just be in my style, right? Or think of it as songs, right? So if you have, all of a sudden you can have 100 songs that sound like Taylor Swift, but they're not Taylor Swift, right? I'm sure Taylor Swift would have to have something to say about it. Yeah,
there's a famous song example recently that was like the Robin Thicke Blurred Line song. I think the Marvin Gaye estate sued them and said, no, this is, you're copying Marvin Gaye. But really, I think the court kind of ruled in favor of Robin Thicke and his production team. They're like, no, it's not enough. It's not similar enough to infringe on the copyright.
Right. I think the issue
definitely influenced,
So the issue with LLM is just they can do it so much faster, right? So whereas you can come up with one song in a month, maybe, right? All of a sudden you can come up with 100 in a day.
Right. And you're seeing this in music right now with, AI generated music. You can generate hundreds of songs per day, potentially, that sound just like a number one song right now.
Exactly. Yeah. So that's what the underlying problem is. I think you see it more in music than in books now, but it'll go into the books, it'll go into paintings and into the artwork, right? It'll go into everywhere. That's why I'm saying, from my perspective, I think there'll be a shift on how like business in the art space is being conducted and how artists ultimately get compensated.
It's a really interesting thing that we're teasing out here, which is the legal professions and our construct of legality and copyright, how it kind of shifts with the times, right? Because I think what you're describing is, if I made one song in the 80s that sounded like Michael Jackson's, like whatever, great. But now, because you can take Taylor Swift to make 100 songs that sound like her instantaneously, the legal apparatus and frameworks need to adapt to that reality.
Exactly. Yes. And
that's the argument that Taylor Swift's IP lawyers are making.
Probably. I mean, right now it's almost with AI, it's like trying to have the legal framework adapt to AI. And sometimes it works, sometimes it doesn't, just like with the copyright and fair use. Right. So it ultimately either be a Supreme Court decision or, the federal government would decide they would have to legislate at the federal level, because otherwise you're going to have state sporadic legislation and it won't do anyone any good.
Right. Which would be the next step. If it gets all the way to the Supreme Court and I get a ruling I don't like, well, then I turn around and go to my lawmakers, my elected officials. I say, hey, this is not fair. You need to
Exactly.
legislate
But
here.
that takes time. Right? On
Yes.
the other hand, you can also make an argument, playing the devil's advocate here, that you need to let technology develop to figure out where the issues are. And you can't stifle innovation with too much legislation, because then people would just go to other countries to do the same thing.
Really fascinating. Well, let's wrap up with some rapid fire questions. What's a misconception about AI and IP you'd like to debunk?
That IP does not apply to AI. It does. There's a lot of AI patent applications that are being filed, and a lot of AI patents that are being issued by the Patent Office.
What regulation or policy development do you think would most help startups building AI today?
I would look at NIST or ISO frameworks for AI governance. Otherwise, the way the environment is right now, you can develop AI, just develop it.
What's the most surprising trend you've seen around founders and IP strategy?
The resistance to IP. Yeah, not a lot of startups want to file for patents, and when they realize that they do, it may be too late.
What's a bit of advice you give every early stage founder about working with legal counsel?
Shop around to find a legal counsel that you like, has expertise, and that you can trust.
Where do you think the next wave of AI innovation is coming from?
I think it'll be in healthcare. There's a lot of AI movement in startups that applies to healthcare, to help develop drugs, particularly in drug discovery. So I think we'll be seeing a lot of innovation there.
Yeah, that's really exciting. And healthcare and medicine tend to lag, 5 or 10 years other industries. There's a lot more regulation there.
You're absolutely right, Brian. But at the same time, it also takes 5 to 10 years to go through all the clinical trials and find out the drug that you like.
Right.
AI can speed that process up.
Yeah, very exciting. Reading and hearing about, basically models of humans where they can test every compound all at once, against like human simulations, and kind of know exactly how that compound will be, digested and will impact your systems. And
exactly
really
right. It speeds things up. I mean, the problem you often run into there is that those compounds may be creatable or not. Right. So you have to find the compound that you can create in the lab and then apply.
Right. What's a piece of tech or legal writing that changed how you think about your work?
It's not. So I like Brian Garner, right? Just for legal writing, active legal writing. I guess if you're thinking of it from a technical perspective, non-boring legal writing that doesn't put you to sleep and sounds like you're reading a statute, I would say for all startups and also, attorneys who are just starting out, read how Brian Garner writes.
If you could change one thing about how the legal community engages with AI developers, what would it be?
I think the legal community needs to come up to speed on math and AI systems, so they actually know what they're talking about instead of just using the buzzwords.
What's a part of your work that you wish more founders understood deeply?
That there's some attorneys who actually know how AI works, and we don't just focus on legal. We're also looking for the business case, which I think where miscommunication often lies, because there's this perception that attorneys are a bunch of naysayers telling you what you can't do. We really are there to guide you to make sure you don't get into legal trouble, and at the same time also expand your business.
Yeah, that's always the funniest part of working with lawyers and attorneys is how cautious they are. They're trying to keep you out of legal hot water. That is like your primary function. It's like,
yeah, no, I agree with you, because that is our job, right? But at the same time, you can't legally stifle the company to non-existence.
Right. So looking forward 5 years, what's a development in AI law, this area you hope to see realized?
I think more and more law firms will be using AI, and you can kind of tell that what's solved and how fast they're growing. I think the value actually will be the AI would help rid attorneys of the busy work and help them actually focus on the legal work.
Right. It's almost as if everybody now with AI has a team of people working under them, whether you're, a paralegal or associate level person all the way up to a senior partner. Now everybody kind of has with AI kind of these agentic systems that help them get their work done.
Right. And they're great, right? Especially if when you start looking at a number of these systems, they are fantastic. But at the same time, and I think all attorneys need to know how AI works and also reviewing the results, because there's tons of cases all over the country with AI creating fake case law and then citing those in motions, and then those being caught by judges and the other parties, right? So there's a lot of traps that you can fall into, but at the same time using the AI the right way and verifying what the AI product is a huge step for attorneys.
Thanks for coming on, Dina. I learned a ton. I'm so glad to have this podcast because I get to talk to experts like you and learn something new. Thanks. Thanks again for the time.
All right. Thanks, Brian. And thank you for having me.